CarePoint Physical Therapy versus Empire Fire and Marine.
John Betts for plaintiff.
Alexis Johnson on behalf of the defendant.
Good morning. What, if you guys had an opportunity to speak?
Well, we don't seem to be able to do anything with this case, Judge. If we go back to August 11th, I filed a motion to compel discovery because we filed some discovery requests. The defendant objected to everything, wouldn't tell us the name of any witnesses, wouldn't provide us any documents. And when we had the hearing on August 11th, I heard you to say, well, if they won't tell you who the witnesses are and they won't provide documents, they can't use them at trial.
Correct.
So I submitted a proposed order and the defendant objected to that. They want an order that says something about the insurance policy without addressing any of the things that we talked about 2 months ago. So I'm asking the court to enter the order, the proposed order that I submitted pursuant to the court's ruling on August 11th.
Yep, I told you that on August 11th. I made a notation of it. Ms. Johnson, anything you want to say before I sign this order?
Yes, Your Honor. The relief that was requested in plaintiff's motion was not the relief that's stated in the order. And while you did indicate at the hearing that Empire would not be entitled to utilize witnesses that were not disclosed on the witness list, you also indicated that discovery had not yet closed and that we were entitled to amend or supplement pursuant to the court rules. Your ruling in review of the court transcript was centered on producing the Empire policy under protective order, and I specifically asked if that should be stated in the order, which it is not stated in Mr. Betts's order, and you denied any relief in the form of the interrogatories and requests for production that were requested by plaintiff, because our answers, as we indicated at the hearing, were accurate and complete. In addition, since that time frame, Empire has filed supplemental discovery responses and initial disclosures identifying additional information and witnesses based on information received throughout the course of discovery. Plaintiff is attempting to gain an unfair advantage.
Okay, wait, stop. Did you do the policy or not now?
Well, we haven't been able to, because after the hearing, I emailed Mr. Betts and said, why don't we discuss an order? I'm happy to prepare it. He never responded to me.
What about a protective order, Mr. Betts?
Judge, if I may, we only have one issue this morning is, does the proposed order that I submitted reflect the court's ruling?
And it doesn't.
Bench on August 11th?
It doesn't, because I said that she could do a protective order on the issue of releasing those documents.
And Your Honor, respectfully,
I don't have a problem with that. I don't think any that she's entitled to it. I mean, this is a routine no fault auto policy. I mean, there's no state secrets involved in this case.
I don't know what the reason is for wanting a protective order, but if she wants one, I'm going to let her have it.
Your Honor, respectfully, if I may respond. These are issues that were already addressed at plaintiff's motion to compel hearing, and we indicated the reasons why our client requires a protective order to produce the relevant Michigan-specific portions of its commercial policy. The motion that is before us today is Empire's motion to enter our order and not plaintiff's motion. So I'd like to clarify that, first of all. Second of all, the relief requested in plaintiff's motion to compel had nothing to do with witnesses that Empire could at trial or evidence that Empire could produce at trial. Plaintiff's motion to compel sought Empire's policy and additional responses to Empire's discovery. Your ruling indicated that Empire would produce the relevant Michigan-specific portions of its policy under protective order and denied the other relief the plaintiff requested. Plaintiff is attempting to re-argue these issues this morning during Empire's motion, which is inappropriate.
Judge, the defendant filed several dozen affirmative defenses. In our discovery request, we want to know whether they're frivolous, or are they made up, are they phony, is there anything to support them? And the way you support affirmative defenses is with witnesses and with documents. Right. And they have not supplied either one of those.
And Your Honor, we indicated
affirmative defenses, that's fine with me, but they have to us, and they have to give us the documents that support those things. They haven't done it.
Ms.
Your Honor,
Johnson?
This was already addressed at the hearing. Our answers indicated that we were not required to provide this information at that current time because discovery was ongoing, and Your Honor agreed. Your Honor indicated that the Empire was allowed to supplement.
So
its
now
response, and
you've
Empire has
supplemented,
done-
correct?
Correct.
You've supplemented now. So
Correct.
he has everything that you need, that all of your answers. He has all of the witness lists and all of the documents, correct?
I would say that's correct, except for we are still proceeding with discovery. We have the underlying PIP case, and so that's the problem. We're on two different scheduling orders, and we're engaging in discovery on the PIP case, which is obviously going to trickle into this case. So really, for the purposes of today's motion, Your Honor, as you've already stated, plaintiff's order does not reflect the accurate ruling of the court. There's no need to re-argue the motion to compel that was already decided on, and we have the court transcript. I reviewed it. I reviewed plaintiff's motion. The relief that is stated in his order is not the relief that was requested in his motion. The relief that is stated in Empire's order is, and we are asking the court to just enter that order.
My order reflects the court's ruling.
You, Ms. Barbaro, Ms. Johnson, what order do you want me to enter?
It's attached to our motion for today. It's under exhibit, sorry, I apologize. It's under exhibit A. And the order simply states that Empire is to produce its policy under protective order, which Your Honor ruled on already,
Yes.
and that plaintiff's motion to compel the remaining was denied for the reasons stated on the record, which was also accurate.
It was not denied.
Well, except that it wasn't denied, except you still are stuck. You can't continue to, that's what I'm saying is whatever you haven't produced as of today, you're done, except for the protective order.
We're not asking to produce more information, but at the motion hearing, we simply indicated that.
But I'm saying to you that this document doesn't reflect the fact that if you didn't already give it to them, do you think you have everything, Mr. Betts, or not?
I haven't seen it. I mean,
Okay,
that's-
so you're telling me that she's lying, that, stop talking. You're telling me that she's lying, that she says she gave witness names and documents and that you didn't get any of that?
I haven't seen a thing since August 11th or whatever that hearing
Ms.
date.
Johnson?
Your Honor, we filed supplemental disclosures and supplemental discovery responses on September 22nd. And I would also like to point out the plaintiff has never filed initial disclosures. I mean, we don't even, we have, you know, we've been complying with every single discovery requirement under the court rule. And we're here today with a plaintiff who hasn't even filed initial disclosures.
There is no initial disclosure in district court.
Except Your Honor ruled at the status
2302,
conference and made that.
Quit talking over her, Mr. Betts. Stop talking, okay? We're on the record. You cannot just continue to interrupt her. She hasn't interrupted you. Stop it. Go ahead, Ms. Johnson.
At the status conference in May, Your Honor indicated that she would like initial disclosures filed. And that is stated in our first initial disclosures that were timely filed on July 2nd. On September 22nd, Empire filed supplemental discovery responses in the form of answers to requests for admissions, answers to interrogatories, and requests for production of documents, in addition to supplemental initial disclosures to highlight all of the evidence that we have obtained from the underlying PIP suit that was discussed at the pretrial conference this past month with Your Honor. Plaintiff has not filed any initial disclosures. Plaintiff continues to be disagreeable.
I did tell you, Mr. Betts, now stop, Ms. Johnson. I did tell you, Mr. Betts, to file an initial disclosure on this case.
I'd be happy to do that, Your Honor. The court rule says it does not apply to district court cases, but I will be.
Okay, good. You can appeal me. I'm telling you to do it.
Okay, I'll be happy to do that.
And Your Honor, respectfully, you know, I don't mean to belay into other issues in this case. There's just been a lot of procedural holdup that really has not been on the fault of Empire. And the reason that we submitted the order that we did is because in reviewing the transcript from the motion to compel hearing, it appeared that the ruling was that Empire would produce its policy under the protective order.
Right now, I got it. And I want it, the policy is to be produced under a protective order. If you guys can't figure it out in the next 2 weeks, I want you to call the civil department and we'll have a hearing on the protective order, okay?
Okay.
Understood, Your Honor.
Your Honor,
Wait, stop. Do you understand, Mr. Batts?
I'm sorry. I understood the order
And
that
the policy is to be produced under a protective order in the next 2 weeks. If there's a problem and you guys can't work it out, call the civil department and I'll get on and I'll work it out for you. Do you understand?
understood.
Okay, then once that is done, you've already done your supplementals. So anything that hasn't been produced as of today's date, minus the policy, anything that hasn't been produced by Empire can't be used at trial.
Your Honor, could we also include language in the order reflecting plaintiff's initial disclosure obligation?
I'm going to get to that.
Okay.
So anything that hasn't been produced as of today, or any witness name that hasn't been disclosed as of today, can't be used at trial.
And Your Honor, I just.
And then plaintiff to provide disclosure statement within 2 weeks.
And Your Honor, if I could just make a record, just because Mr. Betts has indicated that he has not received the supplemental initial disclosures and supplemental discovery responses, I will email him both today, but I would like those to be included as evidence that's been produced and used.
That's as of today, I said. So
Okay.
as of today. And with that, otherwise I'm going to adjourn this to 10 a.m. on the 17th of November. Paige, is that right? I don't think your mic's still working, Paige.
Here.
Oh, yeah, it's 10 o'clock, okay?
Can we do 11?
Yeah,
Okay.
That's fine, Your Honor.
11 o'clock. And so if you have problems with the disclosure or with the protective order, call civil and they'll notify me and I'll get on. All right, you're all set.
Thank you,
Thank you, Your Honor.
Thank you.
I have another 9:30 pretrial. But I don't see, okay, she just,
Do I have any, please, Mr. Batts, do I have anybody here on Deborah Neiman? Mr. Bedouin, what case are you on?
Jefferson versus Sadler.
And I don't have Mr. Sadler. Miss Shamoon, what case are you on?
CarePoint versus Allstate.
All right, CarePoint CarePoint versus Allstate on behalf of CarePoint.
John Betts for plaintiff.
Miss Shamoon on behalf of Allstate.
Rachel Shamoon on behalf of defendant Allstate.
And if you guys had an opportunity to speak at all, Mr. Batts?
Well, Your Honor, I did submit discovery requests and I submitted a proposed offer to stipulate to a judgment for less than the plaintiff is asking. And I've been stonewalled. So I think I'm asking the court to enter a discovery so I can try to force the defendant to admit that they filed a bunch of improper frivolous defenses.
Ms. Shamoon?
Your Honor, we also filed discovery requests that were not answered. I believe we provided the claim file, but in this case, there absolutely is no coverage. We're not even in the order of priority. So we do need discovery, including the deposition of the patient, Ms. Wilder.
All right, I'll order discovery. How long do you guys need?
We would ask for a written discovery only 60 days. This is a relatively small case, $10,000.
Ms. Shamoon?
Judge, I would ask for 60 days. We really need the deposition of Miss Wilder, the patient, because we don't follow an order of priority. And we had submitted a denial letter sending her to MACP, so we do need her deposition.
I'll let them depose her.
Thank you, Judge.
All right, you'll get a date 60 days out.
Thank you, Judge.
Actually, I think I have a date 60 days. Paige, what's my December date?
The 15th.
December the 15th. What time, Paige?
Do you want to do 10?
That's fine. December 15th, 10 a.m. All right,
Thank you, Judge. Have a good
Good,
one.
Your Honor.
thank you. You're all set.
Thank
Hey,
you.
Judge.
Yes?
I think Deborah, hers just keeps saying connecting. She
No,
is.
I know. I don't have Citibank on that anyway.
Oh, okay. I just wanted to make sure that you've seen her.
We'll see if we can't call her in a minute.
Okay, thank you.
On Tamara Lopez versus Jessica Wildhide. Miss Lopez, can you
Yes.
raise your right hand? Solemnly swear affirm testimony you'll give in this matter will be the truth, so help you God.
Yes.
Miss Wildhide, can you raise your right hand? Solemnly swear affirm testimony you'll give in this matter will be the truth, so help you God. Yeah, you got to unmute yourself, Miss Wildhide. Thank you. All right, Miss Lopez, go ahead and tell me what happened.
Well, Miss Wilhide entered into.
And Mr. Edwards, I'm sorry, you Mr. Edwards? Yeah,
Yes.
solemnly swear affirm testimony you'll give in this matter will be the truth, so help you God.
Yes, Your Honor.
Okay, go ahead and go ahead and tell me what happened,
They entered
Miss
into a
Lopez.
contract to purchase my home at 3089 East Maple Road in Milford, Michigan. We took the home off the market because I accepted their offer. Inspections were done. They had 10 days after inspections to back out. They did not. Their water inspection showed a tiny bit higher than acceptable arsenic. My water test, not even a year before, showed none. And then a subsequent water test after theirs showed acceptable levels. There was hardly any. We made a concession for $3,000. It was accepted by Jessica Wilhide. And then the day before closing, she backed out. So by this time, my home had been off the market for 30 days. Everything was done per her agent and my agent to make her happy. We all literally bent over backwards. We were willing to do anything. I had put almost $60,000 into this home. It was going to be our forever home, but I have an adopted son who is severely mentally challenged, and I needed to move closer to family. I realized that I couldn't do it on my own. It takes a village. So subsequently, my home was off the market. I was making the house payments on my new home. I was paying taxes on that home. I was paying utilities on that home. And then it was the time of year where not many people are buying a home. We had to cancel a family vacation, and it was a lot of undue stress onto me. Her claims, she was making false claims that there was just so many lies. And then she went after her agent. She reported them to the board of.
Well, wait a second. Let me ask you a question. What, there was a security deposit, there was a earnest money deposit, correct?
There was
Okay, hang on. And so did your agent, when they backed out, did your agent release the earnest?
She would not sign the release to give me the funds to me.
Oh, okay, okay.
That's
Miss
why
Will, I understand now. I understand. Miss
Yeah.
Wilhide
Yes.
or Mr. I'm sorry, Mr. Edwards, trying
Yes,
to find
ma'am.
your name on the document. I mean, in most circumstances, if you go past all of the dates and you back out, you lose the deposit. What, and that's under law. What would be the reason that you're trying to argue that you shouldn't?
So we have a lot of disclosure issues. City water located at the road was not disclosed. We found out after we agreed to the concessions the very next day that there's a stop box at the road. We never would have agreed to the concessions to help cover the arsenic filter if we would have known that we could hook up to the road and just bypass this well. The arsenic levels were 3.1 points over the EPA's regulation.
Well,
for
except that,
drinking
is
water.
it true that you had your inspection, you had you had the arsenic disclosed, and then you accepted the concession?
Yes.
Correct.
Okay, so I don't care what the arsenic levels are. If you had the inspection, you knew about the arsenic and you accepted the concession.
Yeah.
And so what happened after that?
So we went back to her asking, we're no longer satisfied. I was having issues with my real estate agent, which we're covering in a different case.
But I go back to, you have, in the contract, it says you have X amount of days to either accept or reject. And absence, I heard you use the word failure to disclose, and that's a legal term. And failure to disclose means that on some legal document that they were legally obligated to disclose that she didn't disclose.
No.
So you have to tell me what that item was that relieves you of your obligation once the contract period has expired at the release of your monies of your earnest deposit. Do you understand what I'm saying?
Yes.
I mean, I'm only talking about the legal aspect.
Right.
And we did submit an amendment on November 24th, an addendum rather, excuse me, in which was ignored by the plaintiff, saying that she was out of town on vacation, and it was ignored
Okay.
by her realtor.
What
And
was
we're
the
never completely
addendum?
honest.
Tell me what okay, when was the purchase
The
agreement?
supporting document, Your Honor, we did send supporting documentation on October 1st to the court, which included a notarized letter from a neighbor. Also,
I want to know, when was the original purchase agreement
Purchase agreement was November 6th,
of 2019?
19.
29.
November 6th. When was the inspection?
6 days later. I'm sorry, I got a bunch of dates in front of me.
Pardon me for a moment.
No, November 13th.
Okay,
home
so
inspection
November
was done.
13th was the inspection, and you had to sign off by what date?
So I believe it was around November 20th.
But then you did an addendum you raised objections because of the arsenic, correct?
Yes.
And was that the only objection?
No,
At
ma'am.
that point, yes. When the addendum came up, I had Miss Digg flag to confirm that there was water. The appraisal and the inspection never stated that there was city water at the road. It just said,
Okay, and I understand that, but where in the contract is that a violation? It's not, I mean, failure to disclose is like that it's not about that there's a city water hookup. Failure to disclose is that there's severe water damage and they hit it. It's failure to disclose is a legal obligation. So you're using a legal term to
okay,
apply to something that's not a legal obligation. Do you understand what I'm saying?
yes.
Okay, so you can't, you have to wait, Ms. Lopez.
Okay.
I'll get to you.
Thank you.
So you end up saying the water, there's arsenic in the water. I'm not gonna buy it, I object to this or whatever.
We wanted to move forward. We just wanted to rectify the situation. And without us being able to extend our contingency time, I couldn't verify how much this was gonna cost.
Right,
We couldn't go in top dollar on a house. that
I understand
couldn't
that. So
bathe my
what
kids
did you
in.
do? So what did you do?
So we filed for, I don't even hold on. So we filed for an extension.
Okay,
But we were beyond that contingency period. where she wasn't cooperating, you know, she was on vacation.
But
things
you
were
had
going-
raised that the arsenic was an issue.
It was in our initial contract that
Right,
the
right.
water levels
And-
had to be acceptable.
And so, okay. And so on the water levels weren't acceptable. But
Right.
at some point, did you agree on this $3,000?
Without knowing that city water was available. And I understand.
Okay, so how does the city water being available, let's say that you knew right at that point that city water was available, what would you have done differently?
Well, I would have bargained differently. I would have been able to get some contractors in there to see how much that would cost. Like I said, we couldn't afford to pay full price for the house and do that just based on our approval. From that point moving forward is when we ran into a neighbor. This is when I'm still in negotiations. A lady from the elementary school, we submitted her notarized letter, had just said, oh, you know, we're excited to hear that there's going to be new neighbors and you have a young child, blah, blah. And I said, yeah, I don't know. You know, we found out that the water tested bad and I only tested for arsenic and a few other things. And we weren't going to have enough time to test for other things because an arsenic filter would just clearly filter arsenic, not anything else. And being unfamiliar with wells, I wanted more time to kind of figure that out. She had told me, she said, well, did she ever get the foundation stuff figured out? And I go, what foundation stuff? There was no improvement stated in any of her seller's disclosures about foundation issues, but there is a closed cell insulation on the interior walls of the crawl space that she is still denying is there. I have pictures submitted from the inspection and that she complained to the neighbor about how much money she had to sink into the house in regards to a possible grow operation in the garage, which she did substantial changes to the garage with an epoxy floor. There was overhead heating already installed and a gas line in the garage. So a lot of red flags when we were already concerned about potentially, you know, instead of just losing 5,000 of our EMD, getting into
Okay.
a house that we couldn't.
The issue about the foundation, now you can use that word,
Yes.
failed to disclose.
Failure to disclose.
Now you can use that word. That's
So
an
that was the nail in the
appropriate use of
coffin.
that word.
That was the nail in the coffin for us. That's when
That's fine, stop.
Okay.
Miss Lopez.
Okay, Your Honor, I made improvements to the home. Every single home I've had, we put epoxy floor in. There was a heater in the garage. The thermostat was broke. It's very nice to have a heated garage in Michigan. So I replaced the thermostat. We put extra insulation in the walls and painted them to match the epoxy on the flooring. My son was not in elementary school when Miss Wilhide was purchasing the home. He was in a special education middle school because he had severe mental health issues.
Do you still own the home? Do you still own the home?
No, it was finally purchased by a lovely couple from San Diego. And there's-
Hold on just a moment. Hold on. I apologize. Go ahead.
I submitted all the paperwork from the inspection down to all 3 water tests. Mine, not even a year before the home was put up for sale. Theirs that showed levels a bit higher than there should be in arsenic, and then one after that shows none. I have a signed additional agreement of sale paper that is in your paperwork also, that was signed on December 2nd, 2019, that they were in agreement still after all of this to buy the home. We offered to run, I had put a whole house, I'm very organic when it comes to feeding my children and with water that we drink. So I've always had a reverse osmosis underneath the sink wherever we've lived from San Diego to here. We did replace the water softener when I purchased the home because it was leaking. If you look at the inspection report, We had to replace an amp. There was a 20 amp fuse, I believe, where there was needed to be a 15 amp. And there was one other thing. If you looked at the inspection report, there was nothing wrong with our foundation. It's a very, I think maybe a 3-foot high crawl space that has 2 to 3 steps going from the trap door in the front closet. And there's a light down there. They had stored their Christmas tree there, and there was some additional siding that had been there since they had had the house sided. There was a river rock flooring, and that was it. If you look at the inspection report, there is nothing wrong with the foundation of that home. And like I said, we offered a concession to either put a whole house water filter, which Miss Wilhite had it going up to $14,000. My realtor and her agent checked all around. A high class all whole house filtration system installed would been $3,000 to $4,000. And then we also offered a concession to bring in the city water from the road. And I have that from her agent, from my agent, and it is in the paperwork submitted to you. So she, like I said, on December 2nd, 2019, she accepted that. They signed. It was additional agreement of sale. So I think what happened is that she just wanted to back out of this house. She invented conversations with neighbors that did not happen. We had no children in elementary school. My daughter had graduated from high school. My son was in a special, no neighbors with kids in elementary school around us. So she just wanted to back out of this sale, and she's trying to do everything and anything possible to do it. It costs me a lot more than the $5,000 in earnest. My home was off the market for over 30 days. And then, that time of year, December, January, to put a home back on the market, there's not too many buyers. So I was stuck, and we did not go on a family vacation. They're lying.
When did you sell the home?
Yes, we did. I did.
When did you sell the home?
March of the next year. Yep.
Ms.
So I
Wilhite and Mr. Edwards.
Your Honor, we
Anything
were
else?
Your Honor, we were never referring to her child. We enrolled our child at Wixom Elementary, and that's what our business was at the elementary school. It had nothing to do with her children, Your Honor.
We ran into a neighbor who had children at the school, but that's irrelevant.
We had no neighbors with children in elementary school, Your Honor.
Okay, well, you didn't.
But
know
it's
your
a
neighbors.
neighbor. We're not saying that. So, Your Honor, it was a neighbor of hers that we ran into and who gave us that statement that is notarized in front of you, Your Honor. In addition to her water samples, they were sampled by.
Where is this? I don't see, where is this notarized statement?
So it was mailed to her and mailed to the court October 1st.
Yes. It's from Tammy Inch. If I could read, I'll read it into the record, Your Honor.
Yeah, go ahead.
It's this, Your Honor. I'm not sure if that's showing up for you.
Yeah, I don't see, I'm trying to go through and find it. Go ahead and read it.
Yes, ma'am. So in the
I
spring,
see that
this
it's
is
notarized.
This is
And I'm
notarized,
looking.
yes, from Tammy Inch, who is a neighbor and lives literally like a block away from the home located at 3089 East Maple. So it reads, in the spring of 2018, I met Tamara Lopez. She told me that she had purchased the house down the street, 30 East 9 Maple Road, and introduced herself and her daughter. Her daughter was driving Tamara's SUV.
Wait, that she bought this house. So you bought it the year before. You'd only lived there 1 year. Go ahead. Do you know what the purchase price was the year before?
$259,900, I believe.
And what did you try to sell it for? What was the purchase price?
It was going to be, it was appraised at $275, and I agree, the loan amount that they got was for $261.
Okay, go ahead,
It was appraised
Mr.
for-
Go
I
ahead,
put
Mr. Edwards.
Into that home, Your Honor. We
Yes,
thought
ma'am.
it was gonna be our forever home.
Right, go ahead,
My
Mr.
children
Edwards.
are used to living in a nice place.
Go ahead, Mr. Edwards.
Her daughter was driving Tamara's SUV and Tamara was in the front passenger seat. They stayed in the car for the duration of our conversation. My family was outside in our yard and her son had been over our house at the time and a couple of times prior. So I had little background information prior to meeting her. This occasion is only the time I ever spoke with her face to face or otherwise. The conversation started with the usual pleasantries and introductions. She stated that we were still living in the current house in Milford because the new house by us was not ready for them to move into. Tamara then went into a lot of detail about the house and how she had to take $50,000 out of her 401k or IRA to pay for the extensive basement wall repairs. She said one of the walls had a major crack and was not structurally sound and wanted to sue the house inspector she hired for missing such an expensive repair. She stated while it was being fixed, she also needed to repaint the entire house as it smelled of marijuana and was informed, not sure by whom, that previous owners had a marijuana grow operation in the garage. She spoke of many other personal details such as living in California prior to moving back to Michigan 2 years earlier after the death of her husband, among other things. After all of this, we exchanged goodbyes and her daughter drove off while her son stayed and played with my kids. Since this was the one and only time I talked to her, I cannot speak to the trustworthiness of her statements, but she did go into elaborate detail unprompted by me. She seems nice enough for a neighbor, but I must admit, I found the exchange to be odd with her disclosing such personal things to a total stranger. I met Jessica Wilhide while picking up my daughter from school, Wixom Elementary. We were both in the office and the secretary knew I lived very close to the house Jessica was planning on buying. She introduced us since we would be future neighbors, and that is how Jessica came to contact me when the issues came up. I discussed with her my odd interaction with Tamara, and she was very surprised at the information that I told her, as none of this had been disclosed throughout the home buying process. Thank you very much for your time, Tammy Inch. Notarized on.
Thank you. Anything else? Anything else from either
Your
side?
Honor, if you would like, I can get the home inspection from when I purchased the home. There was absolutely nothing wrong with the foundation of that home. I painted the home because I wanted it different colors. Like I said, we were making this our forever home. I replaced the roof. I put in new concrete because the driveway was cracked. That was the only cement that was cracked. I replaced it. I always put epoxy on our garage floors. There was a heater in the garage. I replaced the thermostat. We replaced.
That's fine. I've heard enough.
Yeah, that letter is hearsay and it's all false, Your Honor.
I've listened to both sides, and this isn't a criminal case. This is a civil case, and so it's whatever tips the scales. It's not beyond a reasonable doubt. It's by a preponderance of the evidence. It's which side it leans towards most. And I think that after listening to all the testimony, that my decision is based on the neighbor who has no interest in this at all. And I find that credible. I'm going to find no cause of action and make judgment for the defendant. Everybody have a good day. Thank you. Yeah, and the money's to be returned to you, Ms. Wilhide. And you're all set.
Good morning. Can you hear me okay?
Good morning.
I'm not sure if you're
Your Honor.
Do I have, yeah, good morning. What's your last name?
This is Diane Exegarara.
No, I see you, Miss Seguraris. I have on the phone call that ends in 9000. What's your last name?
That's me, Your Honor. It's Nonis, Nonis. I'm here for Velocity versus Terry Brown, case number 202457 GC.
Do I have Terry Brown? I do.
Yes.
On Velocity versus Terry Brown. Have you talked to Mr. Brown at all?
Well, he's represented by Mr. Finn. I tried to reach out to him back in September via email and I didn't get a response. So I haven't
Mr.
had
Brown,
a chance.
have you had contact with your attorney?
Yes.
Are you expecting him this morning?
Yes. Yes.
All right, so we're gonna have to just wait for a few minutes. Ms. Zagarias, what case are you on?
I am here on First Portfolio versus Brian Stewart. I am here for Mr. Stewart, appearing for Jesse Ammerman, who is the attorney of record.
I don't see that case on my first portfolio. Oh, versus Brian Stewart. Yep. Yeah, that was set at 9 a.m. and it's now 10. We adjourned that. My understanding is they're super close to settlement. I let the other council go. We adjourned it to November the 17th. Let him, Mr. Ammerman, know that, and you're all set.
Okay, 11:17, same time?
Yep, perfect. Yes.
Great. Thank
On
you.
Citibank versus Deborah Neiman, you finally got us, Miss Neiman. I know you were having some problems. Can you hear me okay? Miss Neiman? Miss Neiman, can you hear me? Oh, Paige, let's see if we can get her. Hang on, let me see if I have a number for her. All right, Miss Neiman, can you hear me? No, I don't. All right, and then Gloria Thompson, what case are you on?
Hi, Your Honor, that's mine. For Midland versus Gloria Thompson.
Let me find the file. Hang on just a second. Got it. Midland versus Gloria Thompson. Miss Thompson, can you on? Good enough.
I haven't. Good
Have you
morning.
talked to Miss Thompson at all?
We have not, Your Honor, and we did not get a copy of her answer either, so I'm not sure what she's alleging. I'd be happy to talk to her in a breakout room.
Okay, I'll put you in a breakout room. Hang on one second.
Thank you.
That's it for right now. Ms. Thompson, go ahead and hit join. And then on Velocity, we're still waiting on Mr. Brown's attorney, who is who?
John Flynn.
John Finn, Finn.
Yeah, I have Attorney Wright in my waiting room. Mr. Katz, what case are you on?
I am on Barrington versus Gamble.
And we're waiting on Mr. Gamble.
Okay, I will just put myself on mute and wait until that time.
Yep, or it's a default at 10:30.
Okay, thank you. Your Honor, just as a side note, I do have another court that I'm going to be doing at the same time.
That's fine.
So
And Mr. Wright, what case are you on?
Good morning, Judge. Attorney Katrina Wright. I'm here on the estate of Joe Louis Bonham versus Anderson matter. However, we faxed in a stipulated order for adjournment.
Oh, got it. You want a 30-day adjournment?
Yes, Judge, that's fine.
I'll adjourn it to November 17th. I don't know what time it is that it'll be, but they'll send you a notice, okay?
Okay, thank you, Judge. To you and
Perfect.
your
Thank you
staff.
very much for appearing.
Have a good day.
You too.